What is the NLRA process for resolving labor disputes? Imagine a workplace where disagreements could turn into chaos or where workers feel unheard. The National Labor Relations Act creates a clear path to handle these conflicts smoothly. It starts with the initial dispute and notice process. When a union and employer can't agree on contract terms, the employer must give written notice at least 60 days before the current contract ends. Then, within 30 days, they must inform the Federal Mediation and Conciliation Service about the dispute. This step helps bring in neutral mediators early on to prevent issues from escalating. Next comes the mediation phase. Both sides are encouraged to meet and talk in good faith, with the help of mediators from the Federal Mediation and Conciliation Service. These mediators facilitate discussions, helping the employer and union find common ground on wages, hours, and working conditions. Participation is voluntary, so either side can step away if they feel the talks aren't working. The goal here is to reach a voluntary settlement without going to court. If mediation doesn't work, the dispute moves to the administrative level. The National Labor Relations Board, which enforces the law, investigates unfair labor practice charges. A regional director looks into the complaint and tries to settle it. If they can't, the case goes to an administrative law judge who holds a hearing. Both sides present evidence, call witnesses, and make legal arguments. The judge then makes an initial decision based on the facts and law. The General Counsel of the National Labor Relations Board can review and change this decision, but if they don't, the case moves forward. Once the administrative process is complete, the final decision can be appealed to a United States Court of Appeals. The court reviews the case and can uphold, modify, or overturn the board's decision. This judicial step ensures that important legal questions are properly examined. The law also covers jurisdictional disputes between unions. When two unions claim the same work, the board steps in to decide which union should get the work. They look at factors like the union's history, the work involved, and the employee's interests. If a union uses illegal tactics like threatening workers, the board investigates and can decide which union has the right to representing the employees. For federal employees, the process involves binding arbitration if negotiations break down. An arbitrator then makes a final, legally binding decision. If either side disagrees, they can appeal to the Federal Labor Relations Authority. Before any dispute is settled, the National Labor Relations Board determines the appropriate bargaining unit. This means deciding which employees are represented by a union based on shared interests, work areas, and other factors. Once the union is certified through a secret ballot election, it can negotiate on behalf of the workers. The process also enforces rules against unfair labor practices. Employers are not allowed to interfere with workers' rights to organize or bargain. If they do, the board investigates, and remedies like reinstatement, back pay, or orders to stop unfair practices can be issued. All these steps work together to keep labor disputes fair, clear, and focused on resolving issues quickly. The law balances protecting workers' rights with maintaining workplace stability, guiding disputes from initial notice all the way through legal appeals.